Newsom
Thank you,
and
Your Honor.
ask you to proceed.
Yes. Your Honor, my second point is that the Mcewen plaintiff's education clause interpretation is erroneous and must fail on the merits. The Tennessee Constitution gives the General Assembly plenary authority over public schools. The Education Clause, of course, obligates the General Assembly to exercise its legislative power to provide for the maintenance, support, and eligibility standards of a system of free public schools. Contrary to the view of the Mcewen plaintiffs, this provision serves as an obligation for the exercise of legislative power, not a limitation on the legislature's authority. In Small Schools 1, the court interprets the Education Clause as imposing that obligation and recognizes the legislature's discretion in accomplishing that obligation. The High Court interprets the Education Clause as imposing an obligation on the General Assembly, but not a restriction on its authority. The Tennessee Supreme Court presumes that constitutional language is precisely chosen. In this very case, Chief Justice Page noted that the court's principles of constitutional construction include the presumption of precision in language. The court presumes that the constitutional language has been employed with sufficient precision to convey the intent of the people. The Education Clause does not employ restrictive language found elsewhere in the Tennessee Constitution. For example, the Home Rule Amendment restricts the General Assembly's power to pass private acts unless the act is passed by the approval of a 2/3 vote of the locality. Similarly, the elections and suffrage provision in Article 1, Section 5 provides that the right of suffrage shall not be denied to a person except on conviction by a jury. These explicit restrictions exemplify the precision in constitutional language that the Supreme Court presumes. Framers could have employed explicit language in the Education Clause if they meant to restrict the legislature's ability to fund primary and secondary education to only a single system of public schools, but no such restriction is present in the Education Clause. Yet the Mcewen plaintiffs would have the court infer a negative implication from the constitutional text. But Justice Scalia and Professor Garner warned in their book, Reading Law, The Interpretation of Legal Texts, that the negative implication canon must be applied with great caution. Thus, the court must be on guard against adopting a constitutional construction grounded only on a supposed negative implication to be drawn from the constitutional language. Further, the Tennessee statutes enjoy a presumption of constitutionality in Tennessee courts and should not be held unconstitutional unless the unconstitutionality is clearly shown. Rather, as shown in Small Schools, the Education Clause should be interpreted as an obligation on the General Assembly to provide a system of free public education to Tennessee school children, not as a restriction on its power. The Mcewen plaintiffs' interpretation of the Tennessee Education Clause is erroneous, and their claim is unlikely to succeed on the merits. Third, the Mcewen plaintiffs lack standing to assert a claim under the Education Clause. Again, in the interlocutory appeal in this case, the Supreme Court reminded us that Tennessee courts employ justiciability doctrines that mirror those used by the federal courts, including the issue of standing. The doctrine of standing ensures that courts hear only those cases that they should, and that only the proper parties bring those claims. The Supreme Court in Heifer versus Purdue Pharma stated that when considering the threshold question of standing, the court determines whether a party has a sufficiently personal stake in a matter at issue to warrant a judicial resolution of the dispute. In other words, to determine whether standing exists, the court must focus on the party bringing the lawsuit rather than on the merits of the claim. Standing concerns whether particular plaintiffs are entitled to an adjudication of a particular claim. While noting that some commentators have criticized adherence to the particularized injury requirement of the standing doctrine, the Supreme Court in 2001 in the City of Chattanooga versus Davis refused to recognize a general public rights exception to the standing requirement of Tennessee law.
Mr. Newsom, I was going to interrupt you. I know that we have Rule 12 motions pending that are very specific to standing, and I appreciate that standing is, without standing, there would not be a likelihood of success on the merits. But I think that the standing issue, we're going to be able to take up, in pretty significant detail in looking at those motions.
Your Honor, I'm sure that the court will. However, in order to be entitled to a temporary injunction, the plaintiffs must establish that there is a likelihood of standing among other doctrines. So, Your Honor, I realize that the court at some point may flesh that out further, but it is relevant to the court's analysis of whether a temporary injunction should be granted, and I flag it for that reason. And I appreciate the court's observation, and I agree with it, Your Honor. But if I may, to establish standing, a plaintiff must demonstrate the three elements of injury in fact, traceability, and redressability. Lack of any one of those results in a lack of standing. In this instance, the Mcewen defendants failed to show, as they claim, standing to assert a claim under the Education Clause because they do not show, Your Honor, that they will suffer an injury in fact. To satisfy this element, a plaintiff must demonstrate a distinct and palpable injury, that is, an injury that is not conjectural, hypothetical, or predicated upon an interest that a litigant shares in common with the general public. Similarly, taxpayer standing, which they claim, must be based on some special injury not common to taxpayers and citizens generally. And to demonstrate their standing, the Mcewen plaintiffs must allege some special injury not common to citizens and taxpayers generally with respect to each claim they assert. They seek a temporary injunction based on only one of their claims, that the Education Clause prohibits the General Assembly from supporting education outside of the public schools. That claim is not in any way based on the ESA program's applicability to a particular LEA. In other words, the inquiry they propose would be the same if the ESA program applied statewide. And that is, does the General Assembly lack authority to fund an educational program outside of public schools in the primary and secondary setting? Whatever interest the Mcewen plaintiffs have in resolving that question, it is indistinguishable from that of the public at large, because the Mcewen plaintiffs have no special injury resulting from the ESA program's alleged violation of the Education Clause. They lack standing to challenge the ESA Act on that basis. Again, the ESA program does not abolish the Tennessee system of free public schools that the legislature has established pursuant to its constitutional obligation. It merely provides another option for eligible students who wish to participate. The Mcewen plaintiffs do not have any special injury not common to citizens and taxpayers generally due to the mere existence of such a program. As a result, McEwen plaintiffs lack standing to assert claim under the Education Clause. For these reasons, the state defendants respectfully submit that the panel should deny the McEwen plaintiff's application for a temporary injunction. Thank you.
Thank you so much. We are now going to turn to the BAW interveners. Mr. Neely, are you presenting on their behalf?
Yes, Your Honor. I'm presenting on behalf of the BAW interveners with respect to Metro Plaintiff's motion for a temporary injunction, and my colleague, Mr. Hodges, will be addressing the McEwen Plaintiff's motion.
Okay, I want to ask you all to be mindful of time, because both the state and Metro have taken probably about an hour and 15 minutes each, and I know that your arguments are aligned with the state's, but that you have particular clients with particular interests, but we are going to ask you to be efficient.
Of course, Your Honor.
And Your Honor, I apologize, Mr. Neely. Before we concluded this state, I just wanted to make sure I provided you with the, it was not a statute, it was actually a rule. And I wanted to make sure I provided you with that reference. It is Rule 0520-01-16-.04, subsection 8. It is within the rules of the State Board of Education, and it's under the table of contents. The specific provision is for the agreement and funds transfer. And it states—
Is that applicable to the ESA program?
Yes.
Okay. Thank you so much, Ms. Bergmeyer. All right, back to you, Mr. Neely.
Thank you, Your Honor. The state defendants have laid out many reasons today why Metro Plaintiff's request for a temporary injunction should be denied. But the main reason that Metro Plaintiffs fail today is because they have fundamentally ignored the Tennessee Supreme Court's decision in this very case. And so under that broader theme, I want to draw the court's attention to two brief points. First, Metro Plaintiffs failed to demonstrate a likelihood of success on their equal protection claim because the ESA program regulates regulates LEAs, not counties. And second, Metro Plaintiffs have failed to demonstrate irreparable harm because whatever irreparable harm they have claimed in this case is of their own making. Starting first with the merits of Metro Plaintiff's equal protection claim, they argued earlier today, and I apologize if I paraphrase Metro Plaintiff's words here, but the injury is in the classification in the statute. But the Tennessee Supreme Court on this point was unequivocal. The ESA program regulates LEAs, not counties. It requires LEAs to count as enrolled students who leave to use the ESA program. The funding obligation that counties have is imposed by a separate provision in the Tennessee Code, and that provision applies equally to all 95 counties in the state. Moreover, Your Honor, the main thrust of Metro Plaintiff's claim here is that these counties in the LEAs are, in a sense, interchangeable, that an injury to the LEA can somehow be transmuted to the county. But that was precisely the rationale that the Tennessee Supreme Court rejected in its decision back in May. And that decision did not rest on a technicality, as Metro Plaintiffs argue now, but it rested on the fundamental operation of the ESA program. To borrow Metro Plaintiffs' analogy that they used earlier of the father funding the son's date, if a father gives his son $50 for a date, but the son goes on to lose the money or have a bad time, it's not the father that's been injured, it's the son. In fact, I think as every father knows, and especially my own dad, who's watching today's argument from my childhood home in Brentwood, once a father gives his son money, that money is spent by the son, right? It's the son's money to spend. And what plaintiff counties are trying to do here is to confuse those two very distinct and separate entities. The real thrust of Metro Plaintiff's claim today is that they are burdened in some way by the ESA program. As we've just discussed, the ESA program regulates LEAs and not counties. But even if they are financially burdened by the ESA program, the Equal Protection Clause requires them to demonstrate a burden with respect to some constitutional right. Now, they've pointed to two rights today that they claim they're being treated differentially under by virtue of the Equal Protection Clause. First, their rights under the Home Rule Amendment, and second, their rights under the Education Clause. Well, the first argument can be dismissed out of hand because, as the Tennessee Supreme Court made
The
clear—
Home Rule Amendment is not on the table. We get that. Let's
Right,
talk
Your
about
Honor.
equal protection.
Certainly, Your Honor. The second right that they rely upon to form the basis of their equal protection claim is the rights contained in the Education Clause. But as the Tennessee Supreme Court has made repeatedly clear, those rights belong to students, not to LEAs, and not to the counties that partially fund them. So they're not claiming differential treatment with respect to some right. And even if they could, as the state defendants explained earlier, the program is subject to rational basis. And here the state has a legitimate interest, and the means that they've chosen to implement this program are rationally related to that interest. So for those reasons, Metro plaintiffs have failed to demonstrate a likelihood of success on the merits of their equal protection claim. But even if they could, we get to the issue of irreparable harm. So earlier today, the counties alleged two species of irreparable harm. First, that their constitutional rights have somehow been violated, and second, that the implementation of the ESA program will cause irreparable harm to the operating budgets of counties and their respective LEAs. With respect to the constitutional harm, as we've just discussed, there is none. But even if this court were to find that there was a constitutional violation, the court must weigh the irreparable harm of that constitutional violation against the irreparable harm to parents and children, whose, by enjoining the ESA program, will lose the fundamental right to direct the upbringing of their children. That's a liberty interest that the U.S. Supreme Court recognized over a century ago in Pierce versus Society of Sisters. So the only real irreparable harm here that could potentially tip the scale is this irreparable harm with regards to the financial operating budgets of Metro Nashville and Shelby County and their respective LEAs. But as we point out in our briefing, all of the budgets that Metro Nashville, Shelby County, and the respective LEAs made for this coming school year were made after the Tennessee Supreme Court rejected their Home Rule Amendment claim in May of this year. They knew, as of the date of that decision, that the injunction that was preventing the rollout of the ESA program was solely based on the strength of that Home Rule Amendment claim. So they knew that once the Home Rule Amendment claim was gone, that the state would be able to continue rolling out the program. But they instead deliberately chose to budget and appropriate money as if the ESA program would not be rolled out. That's a mistake that they made. And Your Honor, I'm reminded of a question that I think you asked parents 2 years ago at the hearing we had in 2020. It's a long time in COVID years, but I think I remember that you asked parents and the interveners, well, shouldn't parents start to think about a plan B in the event that the ESA program is enjoined? And we know, of course, that it was. And for the last 2 years, parents and families across the state of Tennessee have been forced to rely on that plan B and keep their children in some of the worst performing schools in the state of Tennessee. But when it came time for Metro Nashville and Shelby County to make a plan B, they didn't. Metro Nashville and Shelby County are not less sophisticated litigants than some of the poorest families in the state of Tennessee, but they chose—
To be fair, that issue came up in the question about why the state had not put anything on the website about the injunction and was still recruiting families to the ESA program. And the issue was the concern about not putting people on notice about what was going on with the program so that they could make plans.
Well, I apologize then if I misattributed the quote, Your Honor, but I think the point still stands. Parents and families have been forced to rely on their Plan B for 2 years, but Metro Nashville and Shelby County, when given the opportunity to plan for this coming school year, chose to ignore the Tennessee Supreme Court's decision in this case and budget money as if the ESA program was not going to roll out. It is a bedrock principle of Tennessee law that a party cannot rely upon irreparable harm of their own making to justify a temporary injunction. And for that reason, they cannot demonstrate irreparable harm, they cannot demonstrate a likelihood of success on the merits, and their motion should therefore be rejected. And if your honors have no further questions, I'm happy to cede the floor to my colleague, David Hodges.
Thank you so much, Mr. Neely. That was very efficient. Mr. Hodges.
Thank you, Your Honor. And I too will also endeavor to be as efficient as my colleague, Mr. Neely. May it please the court, David Hodges for the Natuba parent interveners. The Tennessee Education Clause does these three things. It encourages education, it establishes a public school system, and it allows for the creation of colleges. But one thing it does not do is straitjacket the legislature and limit its plenary power. For this reason, the legislature can exercise its power to create additional educational options. From time to time, the legislature has chosen to do that. For instance, it created this ESA program for 5,000 kids at some of the worst performing schools in the state. It also created a disability ESA program for 30,000 kids who suffer from disabilities. This is in the legislature's power. But under the plaintiff's view, they can't do these things. Now, plaintiffs don't allege that the ESA program makes the state fail to meet its duty to create a public school system. Instead, they say the legislature can do one thing and one thing alone: create public schools. Plaintiffs want to ask this court to rewrite the Tennessee Education Clause to restrict the legislature's plenary power. But if they want to do that, they're going to need affirmative language in the Constitution. Now, the framers of the Constitution, as Mr. Newsom talked about before, knew how to restrict the plenary power of the legislature. For instance, in Article 5, the House of Representatives shall have the sole power of impeachment. Likewise, in the Home Rule Amendment, the General Assembly shall provide the exclusive methods by which municipalities are created. So here we are. The plaintiffs can't find support in the Tennessee Education Clause or elsewhere in the Tennessee Constitution, so they reach halfway across the country to a decision that no one else has followed. No other high court, I should say, has followed. I refer here to Bush v. Holmes. This was a decision of the Florida Supreme Court interpreting their educational clause. And in that decision, they said that the education clause, which mandates the state to create a system of public schools, in other words, it creates a ceiling, they said that it also creates, while the public school system is a floor, it also creates a ceiling. This reading has been rejected by every single state high court to consider that argument. There were 3 courts before to consider it, and there were 3 courts after it that considered it. Why did they reject it? Because the language of those state constitutions do not support that reading. There's nothing in their state constitutions that say anything like that. And the same is true of the Tennessee Constitution. What plaintiffs are asking for is for an implicit repeal of the state's plenary power. But the Tennessee Education Clause does not do that. The framers could have limited it. They could have, but they chose not to do so. The framers knew the kind of language that they would need to include in here if they wanted to do that, if that wanted to be their goal. They could have said that the legislature can exclusively fund public education, or alternatively, the legislature must solely fund public education. But they didn't do that, and they didn't do that for a reason. And what that means is that the Tennessee legislature can do things like create ESAs for kids in failing schools, or alternatively ESAs for kids who are disabled. That is solely within their power. In sum, what plaintiffs have brought here is not a viable claim, and it's not likely to prevail. And for these reasons, the court should reject their motion for an injunction. Thank you. If there are no questions, I'll be happy to yield my time to the other intervener.
Thank you so much, Mr. Hodges. We will turn to you, Mr. Kelsey, and your colleague, Mr. Stevens.
Thank you very much, Your Honor. Appreciate this opportunity to address you, and if it may please the court, I would like to simplify this case for the court a little bit in 3 points. Number one, no Tennessee court has ever found education to be a fundamental right, not one. Number two, no Tennessee court has ever found that the requirement to create a public school system somehow prohibits the state from doing anything else. And then number three, there's no irreparable injury here. There's no irreparable harm for a couple of reasons. Number one, the counties admitted to the Supreme Court that their total appropriations under the ESA program will remain, quote, roughly the same. Ms. Bergmeyer mentioned this. They said that on page 31 of their Supreme Court brief. Their total appropriations will remain roughly the same. There's no irreparable harm. But even if there were, as they stated in their briefs to this court, there are $29 million that have been appropriated this school year to help these school districts. And that would cover, as they claim, these are their numbers, the county's numbers, 3,100 students to participate in the program. And as the state has presented to you the facts in their briefing, only 1,800 students plan to participate this year. So there's money to cover 3,100, but there are only 1,800 that want to participate. So there's no irreparable harm. And if I could just try to put this case again in a little bit of perspective. Of course, Chancellor Martin, you remember what we discussed, but also Judge Harrington and Judge Smith, to give you a little bit of background. The plaintiffs put their strongest claim before this court 2 years ago. They chose what it was. They chose to file, on the county's standpoint, a summary judgment motion on one claim and one claim only, and that was the home rule claim. And they lost on that claim. The Mcewen plaintiffs also included it in their motion for temporary injunction. They had another appropriations claim, which also is not before you today. So they determined this was their strongest claim, and it lost. But at least for that claim, sure, there were some cases for their position, and there were more cases for our position. And ultimately, the Supreme Court decided that the balance of legal authority was on our side. But now they've come back to you with two weak claims that have literally no basis in Tennessee law. And they want you to rule for them, and they want you to do it on a rushed basis with temporary injunctions. And they can't cite you one Tennessee case in their favor for these claims, not one. Even if you were to write the order for them, I'm not sure what case you would put in your order. This time, the law is completely on our side. And for that reason, I would ask you to please deny these motions for temporary injunction. I want to start with the county's motion. And there, again, this was my point number one. They say that no Tennessee court has ever found that education is a fundamental constitutional right. In the small schools litigation, which we know is the most expansive rulings ever from our state Supreme Court on these issues, the state Supreme Court had 3 different opportunities to make that ruling. 3 times they could have said it, and they never did. Now, that is significant because, and again, well, I want to point out that the state or the counties actually acknowledge this. They say in their brief footnote 24, they say, quote, the Tennessee Supreme Court passed over the question of whether education is a fundamental right. There they're speaking of Small Schools 1. So they've admitted this. And why this is significant is because if it's not a fundamental right, and it's not, then on this equal protection claim, which is the ones before you today, the state statute only has to survive a rational basis review. And it easily does that. So it helps low-income children in persistently failing school systems to receive what the statute calls additional educational options. That's what the classifications are based on. They very clearly match that governmental interest. Now, in their briefing, the counties only really cited one case on this point of an individual fundamental right, and that was the Hayne case, Heyne versus Metro School Board. They seem to have abandoned that case because I didn't hear, unless I misheard, I didn't hear Ms. Bussell mention it once today. And the reason they abandoned it is because we pointed out in our briefing, that's not an equal protection case. That is a due process case. And what you find when you read that case is it says to find a due process violation, of course, the court needs to establish a right to life, liberty, or property. And then in that case, the court declared that the individual right to education was a property interest. And it explicitly called it a, quote, statutory right. Not a fundamental constitutional right, a statutory right. That statutory right to education created the property interest. The property interest is constitutionally protected, sure, they pointed out that phrase, by the due process clause. Just meaning that you can't deprive the student of that statutory right without proper notice in a hearing. So that's why the Hayne case was really brought up at all. And as I say, they seem to have abandoned that argument today because I didn't hear it. So what new cases did they bring forth today? Well, we had 3 others. The first one was the Tester case that Ms. Bussell mentioned. And there, that says nothing about education being a fundamental constitutional right. That was a prisoner case about right to work release. So it's not on topic at all. All she really cited it for was for the proposition that if something's mentioned in the Constitution, that therefore it must be a fundamental right. That's not what the case says. That's not what Small Schools, I think, makes it even clearer, actually, that is not the case. And that's not the case that that the US Supreme Court has said either. In fact, it's really just a logical fallacy. That is like saying that all polar bears are white, and therefore, if you come across something that is white, it must be a polar bear. That's a logical fallacy. That's saying just because fundamental rights are found in the Constitution, that doesn't necessarily mean that if you find something in the Constitution, it must be a fundamental right. We all have a right in Tennessee to freely navigate the Mississippi River in the state constitution. I don't think and have never heard anyone make the argument that therefore boating licenses must undergo strict scrutiny and be narrowly tailored to their purpose. It's a right, it's mentioned, sure, but not a fundamental right. Again, the small schools case makes this clear, and I want to point to the other case, which is the federal case, San Antonio Independent School District versus Rodriguez. Now that is an odd bird for sure for them to be citing on their side, because the very holding in that case was that there's no fundamental right to education. That's the holding. Now, granted, that's under the federal constitution. And again, to somehow act like that United States Supreme Court decision based on things going on in Texas says anything at all about the Tennessee Constitution is a non sequitur. But if it does say anything at all, it probably says what the holding was, which was no fundamental right to education. So that's why that case is actually says the opposite of what they say it is. But as I say, I think ultimately what you've got to come back to is the small schools cases themselves that really had the chance to offer this. And again, as the county said in footnote 24 of their brief, the Tennessee Supreme Court passed over the question of whether education is a fundamental right. So there's no Tennessee law that this court can cite to for that proposition. So where does that leave us? Well, it leaves us in the area of having to pass a rational basis review of the statute. And there we want to look to the statute. They claim in their briefing that the state statute, and they said here this today, they said that the state statute, it has a rational basis dealing with, or it has a governmental purpose to fund school districts, but they're misreading this paragraph. So this is in section 2611A1. 2611A1. If you read the whole paragraph in context, I think it will be crystal clear. It says the intent is to give, quote, access to additional options to students who reside in LEAs, that's a school district, that have consistently and historically had the lowest performing schools. So again, the counties point out that the first sentence talks about funding for school districts, but when you read it as a whole, it's clear that the goal is helping children in failing school districts to have more options. And the state Supreme Court has said in Newton versus Cox that if any state of facts may reasonably be conceived to justify the classification, then it will be upheld. So actually the legislature didn't even have to write its state of facts and its purpose into the statute, but in this case they did. They said, so regardless of what they said in the first sentence, the legislature said it wouldn't matter. That wouldn't matter because the legislature said that in the second sentence, its goal was to help these children who find themselves in persistently failing schools. And the Supreme Court has said that you can consider any conceivable state of facts to uphold under rational basis review, which is where we find ourselves today. So here, there is an exact match between the governmental interest of helping these children in persistently and historically failing school districts and the classifications that the legislature used. What did it use? It said, began the pilot program in the Achievement School District. Every single school in the Achievement School District is a failing school, so that makes sense. And in those school districts that had 10 or more failing schools in 2015 and 2018, and 10 or more in the bottom 10% in 2017. So is that classification reasonably related to the governmental interest? Yes, because the governmental interest is to help children who find themselves in these school districts. It's an exact match. So it would even actually survive strict scrutiny in this instance as an exact match. It's narrowly tailored to achieve that end of helping these children, my clients. The legislature started this program in these 3 school districts, which contained 80% of the failing schools in the state. But again, ultimately, it doesn't even have to survive strict scrutiny. It receives rational basis review because education is not and has never been declared in Tennessee to be a fundamental constitutional right. I'll try to keep my next points a little more brief, Your Honors. The counties also will suffer no irreparable harm. I'm sticking with the counties here before I move to the Mcewen plaintiffs, because again, their school districts will not lose a dime. They won't lose a dime because they've already admitted in their briefing that their total appropriations remain the same. But also the statute has what we've described as a double counting payment provision. And so that counts every child who receives the ESA 2 times. They send part of the funding for time number 1, sure, that goes with the student, goes to whatever school they go to. But all of the funding for part 2, all of it goes to the school district. So for the school district, there is 0 loss of funding. And as I said, the counties admitted this, they're briefing, we've discussed it today, $29 million has been appropriated that will more than cover the 1,800 students that they've said will enroll, and it would cover up to 3,100 students. So what's happening on the other side of the irreparable harm comparison? Well, there you've got families like my clients who have filled out an intent to enroll in the program. Even though it was only open for 9 days, there were 2,000 of them who did it. And these parents desperately want the chance for a better education for their children. And stopping this law again, this time on such a flimsy legal argument, would most certainly cause irreparable harm to their long-term learning. They've waited 2 school years already, and they just cannot wait another semester. So the third and final reason that the counties cannot win is, and this is a fundamental jurisdictional argument that is appropriate to be made at the stage of a motion for temporary injunction, is whether the counties have standing to bring these arguments at all. Here, we've got not just third-party standing, which is disfavored in this state, but it's actually fourth-party standing, because you've got the state, which is given rights, let's assuming that it does exist, it is given some sort of right to the students, but then the students' rights are being protected not by the school districts, they're not before you today, nope, but by the counties. They're 4 parties removed from this right that they claim to exist that's never been found in the state constitution. So they don't have standing to bring the claims as well. Again, this program, it's up to the governor to justify his own reasons, but I will remind the court in terms of whether it's in terms of why the governor is choosing to go forward or not go forward. Again, that's for him to say, but there's a statutory mandate to go forward with this program in the 2021 to 2022 school year. It says no later than that. So by following this court's ruling, which lifted the injunction, the governor is actually following the law and still missing it by a year, but doing his best to follow the law as best he can by implementing the program right away. Because again, the educations of my clients, they desperately depend on this. They can't afford another year. If I can, Your Honors, just turn briefly to the Mcewen's claims. Once again,
just keep it sort of brief, Mr. Kelsey, because I'm aware that Mr. Stevens wants to speak as well.
Well, actually, Your Honor, Mr. Stevens had to drop off, and so that's why I'm taking over. So I will keep it brief.
All right. Thank you.
Thank you so much, Your Honor. I would just say there that again, that no court in Tennessee has ever ruled that this requirement to create a system of free public schools somehow prevents the state from doing other things in the education arena or anywhere else for that matter. There are 38 states that have constitutional provisions that do explicitly limit support for private school. These are called Blaine amendments, and Tennessee has never had one. The plaintiffs simply are trying to create it out of thin air. It's not there. Their sole real argument is that the requirement to create this public school system somehow prohibits any other educational initiative. And they brought up the 1977 Constitutional Convention. And I think it's important, and this is a really strong point, Your Honors. I think we have to look at what did the amendment say that they amended in 1977? What did the old one say? It was a racist and terrible provision, but it did have some other words that I want to point out for sure. It said, no law, this is a quote, no law shall be made authorizing said fund, that was the common school fund, or any part thereof, to be divested to any other use than the support and encouragement of common schools. You can't spend education funds on anything else other than common public schools. That was what the old provision said. And they removed it. And they replaced it with the current provision, which just says create, quote, a system of public schools. So they knew how to use the words. If they wanted to limit it to just going to public schools and not going to private schools, they could have just left the words in there that were already in there. And they chose not to do that. Even the Tennessean said that it's, when they described that amendment that year, they said that it, quote, deletes the requirement for racial segregation in the schools. That was a good thing, already invalid. And then they say this, but opens the door to legislative support for private as well as public schools. That's how the Tennessean described the amendment that year when they were voting on it. So there's nothing in here that really that in any way, shape, or form supports the Mcewen plaintiff's position. They're asking you to go with Florida and West Virginia opinion, but they're ignoring the Indiana opinion, the Nevada opinion, the Wisconsin opinion, the Ohio opinion that went the other way and said there's nothing in those constitutional languages that suggest this interpretation. And the reason that Florida and West Virginia went the other way is because they have different words in their constitution. Florida says you've got to create a uniform system. That does have some sort of suggestion that maybe something that's not part of that system, it's not uniform, maybe we have an argument there, but we don't have the word uniform in our constitution. And then West Virginia is even much more explicit. It says that the school fund, quote, shall be annually applied to the support of free schools throughout the state. And it says this, and to no other purpose whatsoever. I'm sorry, whatever. And to no other purpose, whatever. So there, you can certainly argue that there's a negative implication. That language is just not in our state constitution. They wish it were, but it's not there. And so for that reason, the Mcewen plaintiffs also cannot establish that they have a likelihood of success on the merits, and that's why their claim should be denied as well. So, Your Honors, again, thank you very much for your time, and we appreciate it this afternoon.
And thank you for sticking with us, Mr. Kelsey and Mr. Neely and Mr. Hodges. I know you all were on for a very long time and didn't get to speak for very long, which takes us back to you as the cleanup speaker, Ms. Bussell. And I know you probably have a lot to tell us, but keep in mind that we would like you to keep it brief and that we have heard you, we have heard everybody, and we would appreciate just some highlights of responsiveness before we adjourn.
Absolutely, and thank you, Your Honors, for your patience as we walk through this. This is complicated stuff, and I hope that we've been helpful to you today. I just want to begin by saying the state had absolutely no answer to Chancellor Martin's question of why this has to be rolled out so quickly, that in fact the state is kind of stepping over itself in its rollout. No answer to that question. And I'm going to address a couple of those stepping on itself moments a bit later to clarify some of the things that were argued. First, the first that fits into that category is this concept of the 6% administrative fee. Ms. Bergmeyer made much of this phrase ESA award amount, which we actually do find in the statute. In the statute at 49.62605H, it talks about the department can deduct 6% from the annual ESA award amount to cover the cost of overseeing the funds and administering the program. So the question then becomes, what is the ESA award amount? Is it the top dollar that comes from the LEAs, or is it the bottom dollar that's going to the schools? Well, it has to be the top dollar. And when we look at the comptroller's report, in fact, Ms. Bergmeyer agreed based on the comptroller's report that it is the top dollar. And this is Exhibit 14 that was filed with my declaration in support of the original motion. On page 4 of that brief, it explains that the $7,572 is the statewide average. And because that number is lower than the total BEP allocations for Memphis and Nashville, that statewide average is the ESA award amount. And then it goes on to say the state will hold back 6%. So the 6% comes off of the 7572. And then this is literally what it says. Each student will receive roughly $7,117 to put toward private school tuition. So ESA award amount is the big number, the statewide average, comes off 6%, and then 7117 is what goes to the students. Here's the problem. Right now, as we sit here on the ESA website, the state is telling students that each ESA is funded at approximately $8,192 to pay for private school tuition or other approved educational expenses. Keep in mind, despite the statute contemplating that the statewide average would be released as part of the rollout, the TDOE has not told us what the statewide BEP average is. That's not something that an individual school district can know without having the individual allocations for every school district across the state. Instead, the state has just said students are going to receive $8,192. Well, again, that's the bottom line number. So you have to add 6% to that to get to the statewide average. Well, if the statewide average is 8684, as my math indicates, Shelby County is allocated 8,500 or so, which is less than that. So the state already in its rushed effort to roll out this program is miscalculating the amount that at least ESAs in Shelby County should be funded at. Secondly, I'd like to talk a little bit about strict scrutiny and whether that applies to this law. I've heard lots of discussion in the arguments about there is no case anywhere that holds that education is a fundamental right in Tennessee. And that is true. Respectfully, the fact that a court hasn't held something before doesn't alleviate the court of identifying the appropriate standard. And the question is, under the law, how does one determine whether a law is fundamental? And State v. Tester plainly answers that question for us. A right is fundamental, again, for purposes of equal protection, if it is, quote, either implicitly or explicitly protected by a constitutional provision. Now, I don't know where the Tennessee Supreme Court would draw that line. Like, what does it mean exactly to explicitly protect something in the Constitution? The problem with defendant's argument, however, is that the Tennessee Supreme Court in this case has already said that local sovereignty is explicitly protected by the Constitution. And it has also said that plaintiff counties are injured through the ESA Act's infringement on that right. So it's not that we're asking the court to hold for the first time that something is a fundamental right when the case law doesn't support that it is. Of course, education is a fundamental right under our case law and our Constitution. And we know that from this language in Tester. Education is plainly, explicitly protected in our Constitution. The reason that small schools didn't hold that is because it didn't have to hold that. And the courts will, of course, not address a constitutional issue at any deeper a level than they have to. In that case, the state's funding formula was so egregious, and so many school systems across the state were receiving inadequate educations that the state concluded that it couldn't even satisfy a rational basis. So, of course, the court didn't have to address whether it was a fundamental right because it failed on even the most basic level. Well, if this court concluded that this act did satisfy rational basis, then it would have to ask the question, is education a fundamental right? And by identifying the State v. Tester case, I'm not saying State v. Tester controls. State v. Tester wasn't an education case. But when the court is asking whether something is a fundamental right, it has to look to other case law to determine how to do that. And State v. Tester answers that question when it's implicitly or explicitly protected by a constitutional provision. So let's take a look back at the Supreme Court ruling in this case. Defendants are misconstruing exactly what that decision said. And in fact, they are mischaracterizing it in a way that effectively would preclude us from bringing any claim. Basically, what they're saying is you lost on your home rule amendment claim. The court concluded that the ESA Act, that the Home Rule Amendment is not applicable to the ESA Act. Therefore, you don't have a claim under the Equal Protection Clause either. That's what they're saying. Let's take a look at what that opinion actually says. And I would certainly encourage the courts to read the opinion in full. It's not very long, and it really only says two things. One, it says the plaintiff counties have standing to assert a claim under the Home Rule Amendment. And it says, two, the Home Rule Amendment failed on one of its elements because the ESA Act requires school districts to count students and not counties to count students. That's what the opinion says. Never mind that the counties have to fund the education of those counted students because the act doesn't require the counties themselves to do the counting. It is not applicable to the counties in a way that the Home Rule Amendment would apply. So it is certainly a technical argument. And I'm not being critical when I say that. It's just a technical application of that element of the claim. If it doesn't require the counties on its face to do something, the Home Rule Amendment doesn't apply. That is not the case under the Equal Protection Clause. It is analyzed under a completely different standard. And as we cite in our brief, and I would encourage your honors to take a look at the excerpt from Rodriguez that we cite in our reply brief at page 6, as that case makes clear for purposes of equal protection, the question is not whether a statute on its face says this is how everybody's burdened. The question is, are there burdens? Are there classifications? And this act unquestionably places burdens on the county. That is not disputed here. Mr. Kelsey's double counting is exactly the injury that we're talking about. Every time one of those students are counted, the county has to pay for them. Every single time. Whether we decide to pay more money at the beginning of the school year when they reduce the school district's funding, that's just a completely separate injury altogether. But we certainly have to count them next year and pay for them next year, even though they're attending private schools in Nashville and Memphis. And again, for equal protection purposes, the question is, how are you being treated as compared to similarly situated groups? Well, Williamson County doesn't have to count those students when they go to BGA. Fayette County, despite having a 10 percentile point worse proportion of bottom 10% schools in 2017, they don't have to count students who attend private schools in Fayette County. Only Shelby and Memphis do. And that's the injury. Moreover, I can't recall which intervener defendants it was. I think maybe the Dept intervener defendants criticized the plaintiff counties because we didn't plan ahead for this. That ruling, the Supreme Court ruling came down on May 18th, and we didn't plan ahead for that. And if we had planned ahead for that, then we could have, fill in the blank, appropriated more money to cover the loss. Their solution to the plaintiff, to the school system's injury, is for the counties to pay more money. Again, they're completely missing the point. The fact that we are required to backfill that sort of decrease at the beginning of a school year is exactly the problem. No one else has to do that except Shelby County and Davidson County. So I want to go back for just a moment to the Supreme Court's ruling, because this really does dictate a lot of the outcome here. Because again, the defendants are effectively arguing that because we lost on the original count 1, we lose on everything else. And here's the problem with that. In its standing ruling, this is what the Supreme Court said. Plaintiffs have alleged a distinct and palpable injury to the legal interest the Home Rule Amendment was enacted to protect: local control of local affairs. I don't know how that could be any more clear. The Supreme Court agrees that counties, plaintiff counties, their constitutional right to local control over local affairs is impaired by this act. They've already said that. And Tester tells us if an explicit or implicit constitutional right is infringed upon, strict scrutiny applies. Again, we're not saying game over. We're just saying that dictates the standard that applies under the Equal Protection Clause. But there's nothing in equal protection law to suggest that because you don't meet the technical requirement of a home rule amendment claim element, because the counties aren't addressed by name, there's no support in equal protection law that would dictate the outcome of an equal protection case. The the defendants are just misunderstanding how equal protection law operates. And again, the Rodriguez case explains that. The fact that the counties are not called out by name on the face of the bill, while the Supreme Court said that dictates the outcome of a home rule amendment claim, that is irrelevant to an equal protection claim. And moreover, nothing in the Supreme Court ruling suggests that plaintiff counties are not affected by this bill. In fact, their ruling on the home rule amendment claim acknowledges the opposite. It says, while plaintiffs may be, quote, affected by the act, we do not agree with the dissent that this is enough to render the act applicable to them for purposes of the home rule amendment. So we acknowledge they're injured. We acknowledge the infringement on local sovereignty, which is a constitutional protection. They just don't get the protection of the home rule amendment specifically because the act doesn't require them to do the counting of students. That is the Tennessee Supreme Court ruling in a nutshell, and it does not foreclose an equal protection claim in this case.
Ms. Bussell, can you tell me how much more that you have? Your arguments are very effective, but we also have been going for quite a while, so we wanted to wrap up.
I am scratching through my notes. I think I am almost done. I know that I am almost done. If I could just check my notes for a moment and see what's left. And just two more quick points, Your Honor. First of all, we would submit there is absolutely no evidence in this record to establish harm to the intervener parents. There's been a lot of claims by attorneys that parents are harmed, but the only thing in the record on this motion that we have is Metro Schools and Shelby County Schools options that have been available for the past 2 years that those parents presumably have not taken advantage of if they're still unhappy in their schools. And secondly, we certainly have no evidence to support that they are being harmed today. We don't even know where they attend school today. And then lastly, the state has not indicated that it is going to limit applications to the individuals who completed intent to enroll forms. And here's why that matters. There were over 2,000 intent to enroll forms. Mr. Kelsey is arguing, well, that appropriation of $27 million would be sufficient to cover the school improvement grants for those families. Well, we still don't know. The state is not limiting applications to those families. So at the end of the day, we don't know how many families can apply. And all the state has said is that 5,000 can apply if they choose to. So for these reasons, again, we would just ask that the program be enjoined, certainly to the extent that it is taking funding from the counties or the districts. And thank you very much, Your Honors.
Thank you so much, Ms. Bussell. And thank you to all of the lawyers for your very thorough and effective filings as well as arguments. The panel is going to take this matter under advisement, and we will issue a decision as soon as possible. And if there is nothing further, we will adjourn. Thank you.
Your Honor.
Oh, Mr. Wood, yes.
I was just going to ask.
I'm sorry, Mr. Wood. I should have given you an opportunity to respond.
Is that just a couple of quick points, if that's okay? I know.
Please keep it very quick. This has gone quite long. Yes.
Yes, Your Honor. I've scratched out half of my points, but just three quick points. First, with respect to Mr. Newsom's argument, he quoted from small schools and the language about the legislator having a free hand in funding. Your Honors, Mr. Newsom's argument is exactly what the Supreme Court rejected in small schools when it said that the defendants would use the flexibility of means granted by the Constitution to avoid the certainty of responsibility. That's exactly what the state's trying to do here. The certainty of the responsibility is the mandate to provide a system of free public schools. And while there may be flexibility in how to fund that, you still have to meet the mandate, and that flexibility doesn't extend to funding private schools. As for Mr. Hodges and his argument about plenary power, Unfortunately for him, the Court of Appeals expressly rejected his notion in this very case, and that portion of the Court of Appeals order was not disturbed by the Supreme Court. So regardless of whether he might be correct and persuasive in other states, I don't believe that point is going to work here. And finally, Your Honors, with respect to Mr. Kelsey's argument, first, while we don't have the word uniform in the Constitution like Florida, small schools obviously does have similar language about substantially equal educational opportunities. So I do believe that the Florida case is on point. The remainder of Mr. Kelsey's argument was really just arguing the surreply that the court declined to allow him to file. And those arguments are baseless. You can't compare the prior version of the Tennessee Constitution's education clause to the current version and get any insights from it. When the education clause was redrafted in 1977, it went from 292 words down to just 74 words. So it's not as if the drafters just removed the sentence that Mr. Kelsey highlighted about only funding common schools with the Common School Fund. They completely reworked the entire clause. Nothing is the same between the two. It was a wholesale redrafting. I would also finally submit that it's not helpful to compare the two, because by the time that the education clause was amended in 1978, it was so out of date to be meaningless and no one was complying with it. In 1977, before the amendments were passed, we had an education clause in place that required a common school fund that could only be used for segregated common schools. But Your Honors, in 1977, we are 23 years after Brown versus Board of Education, which found separate is not equal, and yet mandatory school segregation was still in the Tennessee Constitution. As to the so-called Common School Fund that Mr. Kelsey highlights, it hadn't existed in over 100 years. We know from the record of the convention that it was lost and declared legally dead in 1873, and common schools didn't exist in 1977. So again, from the record that we have in the Constitution, the prior version of the education clause was completely rewritten. It bore no resemblance to how public schools were being operated or funded at the time anyway, and comparing the two doesn't yield any valuable insights. Very finally, not once in the briefing and not once today during this very long hearing has anyone responded to our argument that when you read the entirety of the education clause, a finding that the state could fund private schools would render the final sentence superfluous, contrary to fundamental principles of constitutional interpretation. No response whatsoever, Your Honors, and that should be very telling about the merits of our claims, that none of the various defendants and interveners can even bring themselves to respond to it. Your Honor, the voucher law should be enjoined, and we very much appreciate Your Honor's time.
Thank you so much. And again, I am so sorry, Mr. Wood, for the oversight and not providing the opportunity for you to reply. As I said, we will take this under advisement and we will issue a written decision as soon as we can. Thanks to everyone and have a wonderful weekend.